So I'm going to try to be very smooth and very quick with everything what I wanted to say forward, because the topic is very large, and of course, like, you have to be very specific what you want to mention. So today we're going to just mention briefly about the competition law, big data, and privacy concerns as being either friends or enemies. Speaking about the background, very quickly, now we do live in a very digital life. I mean, especially with the COVID pandemic, we moved our normal lives to digitalization. And recently I've came across a very interesting point that we do live in post-industrial informational capitalism, which I believe is true, because everything is based online and we overshare our data. So in fact, the digitalization also introduced a variety of unknown features, especially for competition law, and competition law authorities are actually demonstrating that they are quite slow to react on those issues. So the question for today is really, what role does privacy have in competition law? So when I was actually researching for my thesis, and this is how I created this paper, I analyzed the debate through three angles, three main goals of competition law, which are consumer welfare, efficiencies, and protection of competition structures. So beginning with the consumer welfare, the starting point is that any personal protection breaches which is accumulated from big data / big analysis debate might demonstrate that the protection of competition law and competition law structures might lack any methodological ability to analyze such contents. So this is actually the reason why I've structured those debate into three aspects. So when we try to link the consumer welfare to the antitrust regime, we do get problems, especially that there's problems with assessing the competition value of privacy concerns. And sincerely, one of those problems is that when we do look at the consumer welfare, we do get some sort of a price-centric method. So since privacy in itself is not a price-centric feature of any debate, this is when one of the problems comes forward. So the digital market usually provides free for consumer services, which are very highly innovative, and in this respect, the quality comes forward as a very interesting parameter and very important parameter. So when we do look at the example of the Facebook case, and I call it Facebook case because this is one of the cases from Germany, and this one I actually devoted quite a lot of time, was the one from 2019 from Bundeskartellamt. We were given a picture that any distortion of privacy was seen as harming consumer welfare, despite the lack of any price effect. So privacy protection and privacy breaches might in itself enforce a range of very difficult to qualify and features for consumer welfare. So this is only one of the elements. The other element is that we do get an issue with private gatekeepers, which are, I call them private gatekeepers, but they are data gatekeepers, in the sense that those are the company who accumulate enormous quantities of big data. And their power might be seen as being restrained by GDPR in the sense that they do collect our data and we do give a consent. And in this respect, there are two fundamental issues put forward. So first of all, there's a problem, in my opinion, with the right of data portability, which introduced by the GDPR is quite a user-centric doctrine. Nevertheless, it's offering only short-term approach, because for us consumers, the data means nothing as a single unit. But then for those big platforms, the data is a key aspect for them to get money from, and also to innovate and create the knowledge. But also there's a problem with a consent, and the notice and consent scenario is just showing that people are likely to just agree to those aspects without actually reading any terms and conditions. Moving forward, we do have some problems with efficiencies, and efficiencies are very entwined with the protection welfare promotion. But in the same time, the the digital platforms will, of course, depend on valorization of data and a high degree of processing, with data acquisition, of course, being the cornerstone of every debate. Nevertheless, the European Commission rarely looked at the efficiencies in itself. However, we can get some sort of deduction from previous cases. So one of the cases is, for instance, the case when the Microsoft was tying the Windows Media Player to the operating system. So the line of argument of Microsoft was that it was easier for them to actually introduce those program, just because user was already given a program which you can access, watch a film or listen to music. Nevertheless, the Commission disagreed with this aspect because the efficiency element was just irrelevant in this debate, and the software cost was just low, and user could have just easily replicate the program without any issues. And again, applying it to the debate which we do have at the moment in the Facebook case from 2019, again, there was still a vague discussion on efficiency assessment. Potentially, there was some sort of a lens of competition law applicable that efficiency could have been distorted. Nevertheless, there aren't any EU law cases in this respect, and the case was decided on German law in itself. So we do have some sort of two-sided debate going forward if we do need this sort of debate and to take it into consideration. And lastly, the protection of the competition structure. So the key point is that the European Commission still showed some sort of a pragmatic interpretation of competition legal order, and protection of competition structure is seen as one of the key issues. And of course, the competition structure protection will be then seen as derived from the EU treaties as key to establish a single market. When we do look at the prism of digital economy, the protection of competition structure might be limited, and a further normative standard could be necessary to establish that undertaking's conduct is violating the competition law. Nevertheless, this is where the debate about allowing the non-economic goals into competition law comes forward. And in this respect, there's one of the interesting paper put by Edrachi, who actually compared the competition law to and all the social deliberation to the sponge and membrane analogy, which allowed only, with of course sponge being the core of the competition law and allowing only the certain necessary aspects through in and out. So although we do need some sort of guidance put forward, there's still a huge debate going forward, like how to access it. So I'm trying to propose that the instrumentalisation of competition law is necessary to really allow us to tackle all the problems imposed by the digital economy and any potential breaches of data protection. So we do have some sort of two policies available. So target industrial policies and competitiveness policies. And so far, the debate is really about like whether the competition law enforcement should include any broader social deliberation. And to a certain extent, it is correct, because we do have a debate about sustainability, and again, the digital era is still progressing rapidly, and we cannot catch up with everything that's happening. So when we do look at the digital economy competitive angle, we do get a picture of winner takes all approach. So there are various instances to establish an network effect or two-sided markets due to the speedy pace of innovation and high investment. And we can see it because when we do use of Facebook or different platforms, we see that they rapidly change and introduce various new products. So when we do look at the growing reliance of technological phenomenon of big data, there is a overarching concern that the present efficiencies of law should be reflected and should ensure that the social standard is to protect the privacy, but also to protect the competition and consumer welfare in itself. So recently there was a Franco-German manifesto imposed, and this is where the debate was actually sparked. Since the debate was actually to introduce a industrial policy toolkit for the 21st century, which tried to allow and gave us some sort of ideas how we can tackle all the digital aspects. So for instance, one of the recommendation was just to take a greater consideration of the state control and framework of the measures, and also it was necessary to update any measure guidelines, as well as allow to consider the competition on a more global level. Also, the manifesto recommended to consider whether there is a right to appeal of the council, and which would allow to override any decisions of the commission. Yet, what the debate really look forward, that there's a crucial concern that the council decision would need to encompass a greater nature of the political nature. So this is where another angle was introduced, whether we do need a politicization of competition law in itself. So yet the previous enforcement showed that the industrial policy is likely to be very a successful means, especially when we do look at the debate considering the telecommunication back in the beginning of the 21st century in the 1990s. Of course, there was introduced by a large monopolist and breaching of competition law, and industrial policy allowed to actually capture the market. And technically speaking, when we do look at the debate and we do look at the competition in a post-industrial informational capitalism era, we see that there's a lack of integration for any broader concerns, and we cannot really apprehend the new value of the new generalization processes in the competition law. So in fact, even though the digital economy is characterized by complexity, as we do get a form of very economic links, but also we do get an angle of societal relationship with various agents. And this is where the privacy can come through. So also what is necessary that when we do look at the debate forward, we can get that the debate will be extinguished in not three potential aspects. So one of the aspects is really about the political debate. So at one hand, we do know that industrial policy and competition law, even if they are agreed to be mutually different, they interlink each other and they're very used together as a means to ensure that the single market can work efficiently. Nevertheless, this is where the Article 2 of the Treaty of European Union says that the EU goal is to safeguard the democratic processes of the Union. So this is where the topic is very delicate, because we need to ensure whether the industrial policy can in fact be a means to tackle any digital competition concerns. There is also about the debate about the economic sphere, and it's particularly important to consider any potential promotion of any structural adjustments. And in my point of view, this is when we actually need to discuss whether what is the value of privacy, how to define the privacy for the means of competition law, and whether we should look at the privacy breaches as a means to impact the consumer welfare, or whether the debate should be more looked at the big data / big analysis debate, where the knowledge is more likely to, the knowledge and the conduct of the undertaking is more likely to harm the consumers and the competition law, and then privacy should be just looked at the data protection lawyers as a byproduct of this relationship. And lastly, we need to make sure that we can still maintain the competitiveness of the union. So the debate demonstrates that the debate, of course, those two policies are opposing. There are various of the researchers that demonstrate that mutually those two can be quite interlinked together. So everything still should be maintained to ensure that the internal market is the core idea of the European Union. And in this respect, the protection of the competitiveness of the market isn't necessarily mean to ensure that we can get the benefits of the single market and make sure that the competition functions well. So thank you very much for your attention. This will conclude my presentation.